Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, actually I am telling you jurisprudence class. In the last class, we discussed the laissez-faire theory also. Now, we are going to tell you the theory and criticism. Theory of HAL Hart, H-A-T, and criticism by Dworkin. If you study both of them in one and the same class, it will be sufficient for you. Right. Actually, Professor H.A.L. Hart, he has got the positivist view. He has stated that the rules can be modified by the judges. But Dworkin said the law should be based on principles only. No primary rules and no secondary rules. They should decide, the law should be based on the principles only. So this is the criticism. Anyway, Dworkin remained as a critic, whereas Professor Hart has remained as a jurisprudent. Professor Hart says in support of positivism. So he says legal laws are commands, just like our Salman or Austin. Legal laws are commands. They are distinct from sociological and historical inquiries. So decisions can be taken from the predetermined laws. In this aspect only you are getting the so-called predetermined laws, precedents. And moral judgment can't be established by rational arguments. So the law as it is actually laid down has to be kept from the fact that ought to be. So that means law as it is. He has supported the analytical school, right? But Professor Ronald Dworkin, he criticized H.A.L. Hart's version of law. Please remember, Hart says law is a set of rules, maybe primary rules or maybe secondary rules. But Dworkin says it is a system of principles. It is a system of principles, standards, and policies. Now, I will give you an example as to how the principle can withstand or the rule. It is decided in the very famous case, Riggs versus Palmer, 1889. R-I-G-G-S, Riggs versus Palmer, P-A-L-M-E-R. Right. Here what happened is, Riggs' father, she is a lady, Riggs' father, and he is also Palmer's father. He has given a settlement deed in the name of his children, out of which, so let us take it that he has written a will. He has actually bequeathed much property towards the daughter and less property to the son by name Mr. Palmer. Palmer was definitely agreed by this. The reasons may be so many. The reasons may be sufficient to say that Mr. Palmer is a bad fellow, or Mr. Palmer is not looking after father of Riggs, or things like that. But he was given a lesser portion, whereas Mrs. Riggs, she was given a higher portion. So therefore, he was frustrated literally. Ultimately, the result is that he killed his own father. He was responsible for the murder of his own father. Right? Okay, he has faced the trial. That is criminal case. On the civil side, since his father has written a will, then so basing on the Succession Act or the civil procedure, he filed or he instituted a civil suit in the court for the property. So here, what is important? As per Professor Hart says, nobody shall be enriched with his own fault. Nobody shall be permitted to profit from his own fraud, or nobody can take advantage of his own wrong. Is it not? So this is a settled principle of law. So whenever in the insurance causes, you might have been told about this thing. So here, even though the principle says as per the will, he is the successor or he will get his own portion of property. But since he has committed the murder, so it is not entitled for inheritance. This is what is held by the court. So basing on the principle of Mr. H.E.A.L. Hart. Hart says judge can make new rules by using their discretion. But Dworkin says the principles are genuine, the principles are moral, the principles are apolitical. So judges are bound to accept the principles, not the rules. So this is the difference between these two theories. Anyway, Hart's theory is a legal positivism. Dworkin's theory remained as a criticism. Right? So Ronald Dworkin was a tenacious critic of the legal position. So he always says that the law should be based only on the principles, not on the rules. Judges cannot make rules, but we are saying judge-made law. So law consists not merely rules but includes non-rules standards. These non-rule standards are called the principles. The principles and policies deciding what the law should be dependent. That's all, not the rules. So he was the primary legal philosopher of his generation. Who is he? Ronald Dworkin. So his belief was the law should be grounded on the moral integrity, on the principles, and it should be understood as a moral idea. That's all. So according to the theory, the state should act on the principles on the each member of the community. That means everybody should be treated equally. His theory is that in all cases, judges should not make any new rules. They should depend only on the principles. Even in hard cases, yes, they cannot go away from the principles, of course. So he can be categorized as an interpretationist but not a theorist or jurisprudent. But whatever it is, I am sure you will get a question on the Dworkin's criticism. If you write this much, it is sufficient. Please remember, Hart relied on the rules. That means judge-made law. Whereas Dworkin says law should be based on only principles. So who is going to take care of the principles? So this is a subject for more discussion, therefore is called a critic. With this, I am stopping. Thank you very much.